Hello, namaste, Vikram साहब कैसे हैं? Thank you so much for organizing this consultation.
So I think Sanjay ji, thank you so much, and people are still to join. I think we are
Yes.
we have started a couple of minutes earlier.
Nee, I could see a very good enthusiasm. I had sent it to almost 600 people, so people have actually shown interest, and this is very relevant topic actually. So I think when we will be talking and today, so lots of people will be definitely encouraged. So can you hear my voice? Hello?
Yes, sir.
Yes, I hear your words.
Yeah.
Yeah, thank you so much. Yeah.
Okay.
So all those who would be joining, welcome all. This will be a very useful consultation today, and we'll be discussing about the age consent of children. So people would be joining slowly and gradually, but we'll be starting in time. This platform we have used so that people can see it later as well. And very good initiative. This is a tripod initiative by I thought SAIEVAC and NACG EVAC India. Vikram, hi Vikram sir, how are you?
I'm good, sir, and I'm happy to share that Professor D.P. Verma ji has also joined.
Great.
Good afternoon, sir, and thank you so much to be so timely, sir.
Well,
Good
it is nice
sir.
to see you, sir. Nice to see you.
Good afternoon, sir.
Good afternoon. Good afternoon.
Sir, we are just waiting for Dr. Rinchin Chopel. So he is the UNCRC member. So the moment he joins, sir, we will formally start with your permission. Sir, so nice to see you, sir.
So nice.
Thank you so much, sir. Yes, this is. Thank you for everyone actually, especially Vikram. You had indicated this, but this is really nice to see all of eminent personalities here today in the discussion, especially Dr. D.P. Verma. He's our chief guest, and he's the member of Law Commission of India.
So sir, formally we will be talking, but I'm so glad such a comprehensive report, and in the best interest of children, and I'm so happy that the issues have been taken up in so elaborate manner.
Yes. And also, Vikramji, that because people are just joining, so we can just creating a framework that this is actually a great debate, which was going on in India for almost many years. So the final report by the Law Commission probably has actually given us good insight. So I'm happy that Professor D.P. Verma ji himself is participating in this consultation.
So we also have Subhash Chandra ji from Patna, and
okay.
Subhash ji, thank you so much for joining.
Am I audible?
Very
yes,
much,
sir. Yes, sir. Namaste, sir.
Very good afternoon. Namaste.
So, Subhash ji, Professor D.P. Verma, who is member Law Commission of India, is also with us.
Oh, namaste, sir.
And now we are also joined by Dr. Chin. So, if everyone permit, I will formally start the event.
I think let us go ahead, Vikram sir.
So, with everyone's permission, I'm just here to do a little thanksgiving before I hand over the proceedings to Shri Sanjay Gupta ji, who is the chair of NACG EVAC India. I will also request him to share a little about the NACG EVAC and the movement which is spearheading in India. So thank you so much to NACG EVAC India for agreeing to partner for this event, and also to Dr. Renjin Chopel for agreeing to partner or take this forward under the aegis of SAIEVAC movement, which is a regional movement in South Asia. And I'll share more about him and other speakers as we move on. And special thanks to Professor D.P. Verma ji for joining and sharing his insights and little background discussions if he can. So over to Sanjay ji. Sanjay ji, I'll just request that once you welcome everyone, I will take couple of minutes to show a small video.
Okay, thank you. Thank you so much, Vikram.
Over to you.
Yeah, thank you so much. Thank you, Vikramji. And formally, I'm welcoming all the participants, esteemed participants, especially Shri D.P. Verma, who is our chief guest today. He is the member of Law Commission of India. Dr. Rinchen Chopal is the guest of honor. He is the vice chair, rapporteur, and focal point for Asia Pacific, and also the vice chairperson for UN Committee for Children. We have other eminent personalities today. Shri Manoj Kumar Sinha ji, who will be joining us. Ms. Kishori Baruch, she is the DCPO from Assam. Shri Subhash Chandra Sharma ji already has joined, so welcome, sir. Professor Dr. Akash Pandey will be joining. Dr. Bipin Kumar Mishra ji will be joining. So this is like a complete panel who can discuss about this issue of age of consent of children, especially with regard to the child marriages. First of all, I would like to thank I and especially Mr. Vikram Srivastav, who had done a lot of work on this ground. And later, when this issue was under debate, and then finally the Law Commission has taken note of it and finally submitted a report, detailed report, which is definitely is going to benefit the crores of children of India. So with that, I would like to request Vikram to please show this 2 minutes clip, which would give us more insight about this issue. And then we will move on with our esteemed guest panelists today later.
So thank you so much. And I'm just sharing a small video. I think everyone will like it.
Please show in the presentation mode, Vikram. Yes.
The law on child marriage was first introduced in the year 1929, and it will be 100 years soon. However, nothing seems to have changed. Because girls are betrayed by her own parents, community, religious leaders, and others. While the Constitution of India guarantees equal rights and protection of law to girls, state has failed to protect girls from being forced into slavery in the name of early child marriage. Mission 2029 is an effort to change the situation where every girl is protected and is able to live a life of dignity on her own terms, for which the state must recognize child marriage as a violation of human rights, implement Beti Bachao Beti Padhao in the true sense by protecting girls from forced early child marriages, and by providing free, quality and compulsory education to girls till 18 years of age, implement laws and punish the violators. Every girl deserves a happy childhood, free from abuse, opportunities for education, free from illness, and most importantly, freedom to choose. You too can make a difference. Join the campaign against child marriage.
Thank you so much, Vikram. This was really wonderful and sharp and crisp, and actually has set the tone of the consultation. Thank you so much for Vikram. And I thought so. With this, I would like to invite Dr. DP Sharma, DP Verma, sorry, Chief Guest Member Law Commission of India. Sir, my name is Sanjay Gupta. I am the chairperson of NACG EVAC India. Sir, NACG EVAC India full form is National Action Coordination Group to End Violence Against Children. And this is the part of larger forum called SAIEVAC, South Asia Initiative to End Violence Against Children, sir, from which Dr. Rinchen Chopal is Director General, and he is also among the esteemed panelists today. Sir, first of all, I would like to thank you for the Law Commission that a great debate which was going on in entire country about the age of consent, especially for child marriages. So your commission has taken a very thorough note of this, and you have heard all the different opinions which were coming, and finally given your direction. So I would like to request you to share your experiences and how the commission has actually came to the consensus about the age of consent of child, and what is your keynote address for this issue. Over to you, sir. Sir, kindly unmute yourself. Sir, kindly unmute yourself.
Yes. Yeah. Thank you very much
Well, thank you.
for giving me an opportunity to share my views with regard to the report which has been submitted by the Law Commission. And well, it is in the public domain. Everyone has read it. I must say that the Law Commission had received a reference from the Honorable High Court of Karnataka, Dharwad branch, in the state of Karnataka versus Baswaraj, to rethink the age of criteria for consent, taking into consideration the rising number of cases relating to minor girls above the age of 16 years falling in love, eloping, and having sexual intercourse with the boy, thereby attracting the provisions of the POCSO Act and the Indian Penal Code. The Law Commission also received reference from the Honorable High Court of Madhya Pradesh, Gwalior branch, in Vikesh Kalawat versus State of MP, wherein the Law Commission's attention was drawn as to how the enforcement of the POCSO Act causes gross injustice in cases of statutory rape where de facto consent was present. The Law Commission was requested to suggest amendments to the POCSO Act, vesting discretionary power in the special judge to not impose the statutory minimum sentence in cases where de facto consent was apparent on the part of the girl child or where such relationship had culminated in marriage with or without children. Let me tell you in brief that the Madhya Pradesh High Court felt it necessary to bring to the notice of the Law Commission how the operation of POCSO Act in certain cases was disrupting and devastating families in rural Madhya Pradesh by sending the sole breadwinner in the family to join to jail for a minimum period of sentence, at times leaving his wife and children to the vagaries of the social exploitation and that of the in-laws of the prosecutrix wife were not willing to keep her. Where the prosecutrix was unemployed, as it is mostly in the case, the option for the survival are dismal, ranging from prostitution to crime. The state has no obligation under the POCSO Act to provide for basic minimum required for survival of the so-called survivor the enforcement of the POCSO to such cases in its present form does gross injustice. These were the issues behind considering the references of the Honorable two High Courts, and we had consulted a number of human rights activists, academicians, NGOs, and other persons. And I must say that the presentation or consultation with Mr. Vikram Srivastava of this independent thought was extremely valuable in shaping the report of the Law Commission of India. With this introductory remark, I give the floor to you, and once you call me, I will come to the floor. Thank you.
Thank you so much, sir. Thank you so much. And I must appreciate that your the conversation was very much clear. People have actually had very clearly everything, and you have already set the tone, and you have already given the insight how the Law Commission has prepared this report. So I would humbly request you to please stay with us till we have 3, 4 panelists speaking, at least for
Okay.
20 more minutes, sir. And also, for the benefit of the audience, I would request that if you have any queries, if you have any questions, please keep writing in the chat box. Mr. Vikram will take one by one the important questions and ask the panelists. Now, I would request Dr. Rinchan Chupal, sir, many thanks for joining us. We understand you have a busy schedule, and in between schedule to take out time for such an important consultation is really valuable, sir. So, as you are the vice chair for UNCRC and also the DG for South Asia Initiative to End Violence Against Children, so kindly share your views on this entire issue.
Thank you, Sanjay. Am I audible?
Yes, sir.
Thank you, Sanjay, and thank you, Vikram. This is definitely a very important webinar, and also happening on a very important day of the year when we celebrate the International Day of the Girl Child. Yes, as you said, I've already been now through 5 webinars as part of the discourse related to the International Day of the Girl Child on various topics. But I believe that the topic we are dealing with, the age of sexual consent, and how it relates to the best interest of the child, probably is at the center of, everything that we actually need to define to be able to provide the best protection and securing the best way we can the rights of children, particularly the girl child. I want to salute Professor Verma for a very clear and very, explicit explanation as to how the Law Commission of India has arrived at some of the conclusions. And I'm sure by the end of this webinar series, I'll be quite well aware about how and in what way I must position myself as I take this discourse forward, both at the regional and at the global level. As Sanjay said, the issue at the regional level, particularly because ending child marriage in South Asia is one of the most important areas of work we do as SAIEVAC and as NACGs in South Asia. The issue of the age of for the girl child or for marriage, and the debate around the age of sexual consent, the issue around statutory rape provisions, the way the legal interpretations are provided and in different ways in different countries does provide a very complicated scenario. But at the end of the day, I think the focus is to make sure that in whatever position you may be an administrator, a policymaker, you may be within the law enforcement, you may be with the justice system, you may be a social activist, you may be a parent, you may be a child. and you may be also like me, also as a, from the medical profession. We all have different positions and different views on this whole issue of age of sexual consent. But as a member of the UNCRC committee, and having now gone through series of dialogues with different state parties over the last 3 years, I have come to understand that the age of sexual consent is not as something that we can always find a clear-cut, way forward in terms of how we address this. But one thing definitely is clear, that I think the age of sexual consent must find very clear interpretation in relation to what the CRC Convention under Article 3 says, in the best interest of the child. And I think that is what I think must guide the whole discourse. And from what Honorable Professor Verma mentioned, I think some of the Honorable High Court's interpretations do seem to be, taking this perspective into their consideration. And I think this is indeed very, very welcome and encouraging. If you look at Article 3.1, it is very clear and precise. And if I quickly read through it, it says, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. Now, this is something which, even in the CRC committee, when we have dialogues with the state parties or with stakeholders, and even with children themselves, we continuously have intense debates in terms of how do you actually interpret the best interest of the child. Is putting a cap on the age of marriage and age of sexual consent in the interest of the best interest of the child? How does it actually implicate, or how does it affect the enjoyment of rights of young people and adolescents in terms of the different types of services they need, in terms of their biological and hormonal and other, developments, in terms of how they now foresee themselves as individual rights holders vis-a-vis larger community, family, social group rights. So I think it is a very complex dimension, but definitely I think if it is interpreted to ensure that the child is protected, child is assured of social protection, child is guaranteed with a decent way forward in terms of addressing his or her life as we move forward from an episode, I think that is something that needs to be looked at very carefully. And I believe the work that South Asia is doing in this area, and particularly one of the exciting things that we are working on, is hoping that the POCSO Act, all the things that we are discussing today, may actually become a subject for regional learning and sharing, so that other countries in the region and maybe beyond will be able to reflect on their own legal instruments, legislative frameworks in the countries, and then see how best to move forward. But because things are not as clear as it is being debated here, because there's not enough adequate, intellectual discourse that's happening in different countries in the region. So I am very happy to be part of this panel and the opportunity to learn. I look forward to hearing the conclusions and the summary of views that come by. And I hope that I will have an opportunity to meet in person the Honorable Professor Verma at some point in the coming days, and to have a little more intense discussion on this. But thank you very much, and I wish the webinar all the success and good luck with whatever you're doing. Thank you very much.
Thank you so much, sir. Thank you so much. And we were really enlightened that the idea and the concept you are representing South Asia at UNCRC level. So your inputs, your advice, your suggestions are really, really valuable. And thank you so much for that. And so, Vikram sir, do you have got any question till time?
No, no question as such. I'm just
Okay, so I think people are really admiring and understanding the discussion. So we encourage participants to write their question if you have in the chat box so that we can start asking. Because I
just
can see that.
couple of points from my side. So first of all, thanks to Professor Verma for acknowledging the contribution made, and I must say the interaction with the law commission which I had was such enlightening, because the kind of and the quality of question which was being asked, and the concern for the children of India, the kind of concern the commission and the members and the even the legal researchers, the kind of question they were raising, it was very heartening to see so many people who are not otherwise that directly linked to child rights and child rights jurisprudence, but their concern and the way they were looking at it was so heartening, and that reflects in the way that the final document comes out. So I'm
Yeah,
so glad, and to Professor D.P. Verma ji for not only being part of this, but he has become a very, very great custodian and advocate of child rights now, I can say. And to Sir Dr. Rinchin Chopal, he has always been there as a strong support pillar to children and to the campaign of child marriage. And also the fact that uh, somewhere in the past few years, the regional discussions which were happening at the platform of SAIEVAC in different levels, I think the age of consent, the legal stand within India, the legal position in India, was kind of becoming a benchmark for other countries as to their legal reform. And so it was, I think, was also an international challenge of a kind where if we would have slided down the age of consent, it would have had a regional impact, not only an impact within India, but it would have an kind of took back the whole child rights movement in the region, and a lot of other countries who look towards Indian legal system. So who have countries which have the common law system, so it would have had a very, very global impact. So I think I am so grateful that the Law Commission took a position and
yeah.
came out with something which is in the best interest. So I'll stop here, and
Thank you.
we have Subhash Chandra ji. So Sanjay
Okay.
sir, please sir.
Thank you so much. So, thank you, Vikram. I think your deliberation has actually and your efforts has being the fruit, and already Verma Saab have has endorsed the great work done by you and your organization. So we have with us Shri Subhash Chandra Sharma ji. He is Officer Bihar Superior Judicial Service Head Juvenile Justice Secretariat, Patna High Court. Before I come to you, sir, I have few questions, only two questions for Sri Verma ji. Maybe this may help all of us to take this discussion forward. So, Dr. DP Verma, sir. So, just wanted to understand from your perspective, what kind of debate you have witnessed when the report was prepared. I understand that there were different schools of thought, and how on addressing those schools of thought, Law Commission has given certain kind of two three examples or two three ways to tackle those issues. For example, there is one school of thought who still says that the girl has a right to choose at the age of consent for sex. If she is okay, 16 years, 17 years, then why so much hue and cry? And then I understand beautifully Law Commission has given recommendation. So from your own perspective, you would like to hear that, sir. Sir, you need to unmute yourself, sir.
Oh, sorry, sorry. Yeah. Actually, we had worked on this project for several months, and
Yes.
the difficulty we had faced that we knew what is the POCSO Act, what are the provisions about it. But so far as the opinion of the different high courts were coming to us, they were feeling great difficulty keeping in view how this marriage is taking place and girls are eloping, and otherwise it was found that after few years the boy and the girl has a child, and they are living as husband and wife together, and those parents who had lodged complaint, and once they knew that their daughter has married, they became hostile before the court. They want that
Hmm.
if the marriage has taken place, they were going to accept it. Now, here there was a difficulty. The Karnataka High Court was thinking whether the age of consent be reduced or not. And here, the opinion of the Law Commission was sought. What is to be done? Will it recommend for reduction of the age or not? In the other case, the Honorable High Court of Madhya Pradesh had a great difficulty where the same incident had taken place. The girl had eloped, married, she had the child, and once the boy was given a sentence for 10 years, then the girl was weeping before the court. What will happen to me? She said that no one is going to accept in the family. Either she will have the vagrant life, and how she will maintain her child. These were some of the difficulties really faced by the Honorable High Court of Madhya Pradesh. And now the question was, at some stage, this High Court of Madhya Pradesh was thinking whether there can be some humanitarian approach in those circumstances. What should be done? And they wanted that perhaps if certain discretion is given to the special court, perhaps it will be easier for the Indian judiciary to take up such cases, for keeping in view the humanitarian aspects, and the cases may differ from case to case as well. These were the
Okay.
circumstances. Now, if you want to continue, I may say few things what recommendations we have made, or if there is any question, I come again on this forum. What do you say?
Sir, humbly requesting to kindly share your recommendation because you have actually touched the
Okay.
very crucial point. So, if you can conclude
Yes.
this, please.
Yeah. Now, here, the Law Commission considered that certain amendments be brought in the POCSO Act to remedy the situation wherein there is tacit approval, in fact, though not consent in law, on the part of the child aged between 16 to 18 years. Such cases do not merit to be dealt with the same severity as the cases that were ideally imagined to fail under the POCSO Act. The Law Commission therefore deemed it fit to introduce guided judicial discretion in the matter of sentencing in such cases, and it has proposed amendment in Section 4 and Section 8 of the POCSO Act. The Law Commission report traced the historical origin of the age of consent in law and also outlined approaches adopted in the United States, Canada, Japan, Australia, and South Africa, in all of which have lower age of consent. The Law Commission's recommendation favor retaining the age of consent at 18 years to criminalize both abuse and non-coercive sexual sex. By way of mitigation, it has recommended judicial discretion to award less than the mandatory minimum sentence of 10 years and provide guidelines for determining cases that were befitting for sentence reduction. The POCSO Act fixed the age of being categorized as a child at 18 years, thus making it the default age of consent, meaning thereby that once the person upon whom the sexual act is committed is a child below the age of 18 years, consent would be irrelevant for the purpose of attracting criminal liability under the POCSO Act. While the prohibition of Child Marriage Act and POCSO Act appear to be different, they are invariably correlated. Till 2017, exception 2 to 3, section 375 of the IPC was used as a safe harbor for men having sexual intercourse with their minor wives, and only when this exception was read down in by the Honorable Supreme Court in Independent Thought versus Union of India and another did true protection to children against sexual exploitation in the sense envisaged under the POCSO Act actually became a reality now. It is important to appreciate the interlinking between laws. The Prohibition of Child Marriage Act, though very noble in its goal, is a weak law. It does not declare a child marriage void, but only voidable. And while there are penal provisions against solemnizing such marriages, the law does not deal with the question of sexual relations with a minor spouse. The POCSO Act fills in this void, and that was left unaddressed for long, and provides a deterrent against marrying a child and initiating sexual relations with her, as the consequences under the POCSO Act are much graver. It is young girls who are predominantly forced into child marriages, and any dilution in law may very well lead to further exploitation of a girl child. To state further on this point, I must say, in such a situation, any tinkering with the age of consent may compound the issue that already exists. While it is often tried to delink the age of consent and age of marriage, however, it is a reality in Indian society that consent to sexual activity exposes a girl to the risk of early pregnancy and marriage. Thus, in all practicality, the two aspects cannot be divorced from each entirely. At the end, I must say, yet another interplay that has to be carefully considered in the context of the POCSO Act is child trafficking and possession of children. According to the National Crime Record Bureau data of 2021, out of 6,533 victims of trafficking, 2,877 were children. A large percentage of cases of human trafficking were for the purposes of sexual exploitation, for prostitution, and some were even for forced marriages. The POCSO Act is an important tool to combat the scourge of child trafficking and child prostitution. Trafficking can be done in the garb of child marriage, and the POCSO Act becomes all the more important in such a situation. Thus, in considering the issue of age of consent under the POCSO Act, the competing best interest of child protection and consent of child have to be perfectly blended. Thank you very much.
Thank you so much, sir. Thank you so much. And this is your voice and your expressions are so much loud and clear that every sentence of yours is getting inside the heart, and we can clearly hear it very loudly. So just one last question, and then I'll move on to Shri Rinchan Chopal, a very specific question. Sir, what about the cases which has already happened? So what has been advised for that?
No, generally, the decision has already been given in many of the cases. by the Karnataka High Court, Madhya Pradesh High Court, in Bombay and other places. The question is, if these issues are coming in the society and the judiciary feels that something is to be done, and even the judicial discretion cannot be done unless some changes are made under the POCSO Act. Therefore, whatever recommendations we have made, and if it is accepted by the government of India, perhaps some changes will take place in the POCSO Act, and it will
Okay.
be helpful for the judiciary in dealing with all such cases in future. Thank you.
Thank you so much, sir. Thank you so much. All the questions are answered very well. Thank you so much for your presence, sir. I would just humbly request to stay as much as you can with us because this is a really important consultation. And with this, I would
Uh,
like to, sir.
sir, sir, I have some other important business
Okay,
because it is
okay. Thank
already
you.
quarter to four. I
Thank
will
you so
seek
much,
No,
your
sir.
no,
pardon. Okay,
yeah,
Yeah,
okay.
thank
Thank
you
you.
so much for it.
Professor Verma,
And for
Professor
on
Verma,
behalf
thank
of
you so
NACG
much.
back and yeah, yes, yes, Vikramji.
No, Professor Verma, thank you so
Yes, we
much
can be.
for your presence, and we will share the link of the videos and all, and we will definitely come and meet you, sir, soon. Thank you, sir. Thank you so much.
Okay, most welcome,
Thank you
most
so much.
welcome, most welcome.
Thank you so much. Thank you. So this was Dr. D.P. Verma, our Chief Guest and Member Law Commission of India. And he has given a very deliberate response to all these questions. And also he explained how the Law Commission has taken note of all the issues and submitted their report. Dr. Inchan Jubal, I have this question with you now, and then I will move to Shri Subhashji. Dr. Inchan, you are witnessing many countries, not only India. So how do you see from that perspective this stand of India will impact the other countries as well? What kind of debate they are going through? If you can enlighten on that.
Thank you, Sanjay. Definitely, as Vikram mentioned earlier, the work that is going on in this area in India, particularly in the last few years, has been extremely useful in terms of my dialogue with different countries in the region, particularly through the agenda of ending child marriage in South Asia. And as I mentioned earlier, every country has their legal provisions. They have their, instruments that address issues of access to justice. The issue of age or definition of the child, the age for child marriage, issues around which we have discussions on harmful practices. The every country has a lot of inputs to make. But I think the important aspect is that the gap between the age of sexual consent, the understanding of what the age of sexual consent is all about, why the age of sexual consent is important, and the age of marriage, I think are two areas which do not seem to harmonize or which do not seem to come together to be able to provide that proper blanket, very clear cover, legal cover to protect children, particularly the girl child. And the independent thought versus the state, the issue on statutory rape has made a huge, ripples in the discussions in 8 countries on child marriage, and every country started looking at that as one way of strengthening their efforts to end child marriage. Now, this whole discourse of age of sexual consent vis-a-vis the age of child marriage, and then more importantly, how all this actually translates into the best interest of the child is, I think, now the crucial part. And as I mentioned before, we can very well say that the age of sexual consent and age of marriage should be same. But you know that puberty, now children attain puberty earlier, sexual development takes place faster. We live in a very fast and advanced age of development with a lot of, mass media and digital technology in, all types of information, and then with all that dark world through which we get all this information and unwanted materials that target children, it actually adds a whole lot of dimension to the discourse. And I think it's important at the end of the day that there is a strong need to find a suitable balance between what the children actually need in terms of protecting them as well as what is good for them. I think we need to find a balance and do not necessarily also make it so complicated that we tend to revert back our whole modern legal frameworks to bring in this whole issue of parental control and paternalistic societies back, adults deciding for children. There are a lot of discussions. I think it's not as simple as we, some of us lay minds think. I think it is something which India is doing that can have a very strong impact in terms of discussions at the regional level. And I think we should take the outcomes of this webinar as a substance for holding a regional learning and sharing at some point where we bring all colleagues from the 8 countries together and have intense discourse around this, and then maybe find ways and means to take this into the discourse of the legal and judicial fraternity of South Asia, including the national human rights institutions and platforms. But I'm really, really excited with the way the webinar is taking shape and with the way Professor Verma outlined some of the recommendations and findings from the Law Commission. This is really useful. Thank you very much.
Thank you so much, Dr. Ranjan Chopal. Really, thanks for valuable insight and also about giving us idea of organizing a regional consultation where the other SAARC countries or other countries anywhere in the world can learn from India's experience and get into this similar kind of action at their level. So thank you so much. We have been joined by Dr. A.K. Pandey also from RML Law University. Thank you, sir. बहुत दिनों बाद आपसे मुलाकात हो रही है webinar पे online. Thank you so much for joining us. So Professor Shri Subhash Chandra Sharma ji is waiting. She is Officer Bihar Superior Judicial Service, Head Juvenile Justice Secretariat, Patna High Court. So I would request Vikram to lead this discussion with Shri Subhash Chandra ji.
So thank you, Sanjay ji. Thank you so much. And I recently met Subhash ji in Patna, and the depth and width of understanding and knowledge he carries on law, especially related to children, is amazing. And I had a very, very great discussion with him, and that discussion I always remember and cherish. So I'm nothing much to say, just that he is also a proponent of best interest idea under the child rights jurisprudence. And he has been anchoring the JJ committee at the Patna High Court for a very long time now. So over to you, sir, and we would like to hear from you, your comments, reflections on the age of consent issue, and also what the Law Commission report opens up. Obviously, it's open for the Government of India to accept or reject what they have recommended. But over to you for your reflections. Thank you.
Thank you, Vikramji, and a very good afternoon to everyone. I'm obliged for getting this chance to place my view on this webinar organized by the Campaign Against Child Marriage on the topic Age of Consent. In relation to the judgment of the Honorable Supreme Court of India and Independent Thought versus Union of India and the 283rd report of the Law Commission of India on the topic we are discussing today. As a law student, at the outset, I shall try to discuss the concept of consent in conceptual, jurisprudential, and practical point of view. To my mind, the existence of consent is a question of fact, and the effect of it is purely a question of law. The Law Commission has referred the definition in its report of age of consent as mentioned in the Black's Law Dictionary as the age of consent is the age at which a person is considered legally capable of agreeing to marriage or sexual intercourse. So if we notice the definition of this age of consent, there are two factors relating to the age of consent. The first one is the age of legal capability of agreeing to marriage. And the second one is the age of legal capability of agreeing to sexual intercourse. But what I have noticed from the entire report that the focus is more on the second factor, that is the age of legal capability of agreeing to sexual intercourse. And the probable reason to my mind for taking up only this second factor is, or for prioritizing this aspect by the Commission is that the second factor includes the aspect relating to the age of legal capability of agreeing to marriage. So that may be the probable reason. Now, the Law Commission has deliberated upon and submitted its report on two basic points as per the references made by the Honorable High Court as discussed by Professor D.P. Verma. The validity and effect. The first one is the validity and effect of the de facto consent of a prosecutrix below the age of consent, and the prosecutrix being below the age of consent if her relationship culminated into marriage. These are the 2 points that were referred. In the independent thoughts case, the exception 2 of the section 375 of the IPC was challenged on the ground that it is discriminatory since it lowers the age of consent only because the girl is married, thus violating Article 14. Further, there is no rational reason for the age of consent to be higher for a girl child only because she is married. Hence, the exception 2 is arbitrary in setting the age of 15 years for marital rape, and that was rightly upheld by the Honorable Supreme Court that has discarded that exception 2. Now we are talking about that age of consent, and the Law Commission has also discussed about this. I think you must be knowing the way back in 1928, probably it is on the 25th June 1928, a committee on the age of consent was appointed by the then Government of India, comprising 1 chairman and 5 members, which was later extended to 9 because that, 4 MLCs were included in that committee, and one of was from the Bihar, Mr. Sachidanand Sinha. While considering this aspect of age of consent, because that committee was dedicated to report on the single point, that is the age of consent, and that report is almost in 9 to 10 volumes. Very voluminous document was prepared by that committee. And a massive exercise was done by that committee by getting direct opinions of around 6,000 persons, 1,200 local governments, considered 900 written statements on various sections of the society, visited 100 plus villages, and recorded oral evidences of around 4,000 witnesses. A format of questionnaire was also drafted and circulated amongst each section of the society, and finally submitted its report after 1 year, that is in the year 1929. As I was hearing Professor Verma, the Law Commission has also exercised in another way, getting the inputs from the international societies regarding that age of consent. But what that age of consent committee has done, it has extensively considered the provinces, the societies within the country, the common people, for getting the inputs. The committee has submitted, that is the age of consent committee, has the recommended 40 points for consideration. Amongst that 40 points, the one was the raising of age of consent for the protection of a girl against rape by a person who is not her husband to 18 years. And the second recommendation that is out of that 40 recommendations was the categorizing the sexual intercourse by a husband with his wife below 15 years of age as an offense under distinct heading, that is marital misbehavior. Now what this is the, I think, if I am not wrong and subject to correction, this is the first exercise which has been assigned to the Law Commission for considering the lowering of the age bar regarding age of consent. Earlier, many committees, many recommendations were made for enhancing that age bar. So this is peculiar, I think. Now, I was expecting when this Law Commission was assigned that work, I was expecting with that impression of the age of consent committee that similar kind of exercise would be taken by the Law Commission. Although I'm not criticizing the Law Commission, it has did a marvelous job. Because that this topic requires an extensive deliberations, extensive research. This is not a casual issue. This issue should not be confined to the recommendations only. It was a chance to examine each and every aspect, because any finding relating to the age of consent has several ramifications with respect to its social, moral, religious, or legal impact. So the entire thought process of the Honorable Supreme Court of India and the Law Commission revolves around the concept of age of consent. That's why we are discussing here. So we have to understand the law of consent first to decide the proper age of consent. Now, in a general sense, consent is quo animo, what we used to read in the law books. That is the quo animo of the act. So consent is an operation of the mind, implying positive mental action, and consenting is to be willing as a condition of mind. If I put it in a simple way, I can say that the consent is a concurrence of wills and consists exclusively of the intention of the mind. It must be kept distinct as much from mere absence of dissent as from a wish or instigation. The absence of dissent or even mere submission is not consent. Submission, far from being consent, is totally different from it. For there may be submission without consent. And even while the feelings are repugnant to the act done and submitted to. Hence, every consent involves a submission, but it by no means follows that a submission involves consent. For example, take the case of a surgical operation. For extracting, somebody goes to the physician, surgeon, for extracting the stone, which is for the man's benefit. A nervous patient will often, on the first smart of the surgeon's knife, like to escape it altogether, even at the risk of death, and would escape, but for the chloroform administered to him, and still he is said to consent to the operation. So the physical consent is altogether different from consent. The consent of the intellect is the only consent known to the law. You cannot qualify the consent. It is either a consent or no consent. A famous jurist, Justice Joseph Story, who was Associate Justice of the Supreme Court of United States, in his work Equity Jurisprudence, defined the word consent as an act of reason accompanied with deliberation, the mind weighing as in a balance the good or evil on each side. Now this distinction between the will and consent has been totally ignored by the legislature in recent days, and the two words often used synonymously. Strange as it may appear, even the distinction between the opposition to a person's will and the mere absence of his consent has also been ignored. The operation of the mind in regard to one's own act corresponding to the consent to another person's act is a designated volition or willing. Thus, will is the state of mind in favor of a man doing an act which he intends and decides to do. And a man is said to will one's own act as he is said to consent to another's act. The cause of consent like that of will is separate and independent of consent, and a person may consent to an act of another as he may will his own acts, even though he does not wish for or approve of them. You must be thinking that why I have entered into the difference between the will and consent arena. The reason is the scheme of the section 375 of the IPC itself. If you go through that section 375 of the IPC, which explicitly recognizes this difference, you must have noticed that the first circumstance under this section, which constitute the offense of rape, is the act of a man falling under that clause A to D that has been given under that section. If that act has been committed first against the will of the prosecutor. The first circumstance is if that act has been done against the will of the prosecutors. And the second circumstance is without her consent. So the difference is very clear. One may, that is a girl, may have a will for intercourse without consenting to it, as she may consent to it without having a will for it. And the intercourse will be rape if there is no consent, but it is not a rape if there is no will. Why? Because mere absence of will, unlike absence of consent, will not constitute rape. However, if the act consented to by her is done not in the absence of her will, but against, that is in active opposition to her will, as will comes into play immediately prior to her act, and if against the act must from its nature be held to be indicate a revocation of her prior consent to the act. So there is a glaring difference that has been preserved under the section 375 of the IPC. In the subsequent legislation related to that sexual offences, that has been diminishes, that has been forgotten by the legislature, sorry to say. Now the consent being strong positive mental attributes thus requires a mature mind. That is a mind capable of analyzing the reason, accompanied with deliberation, the mind weighing as in a balance of good or evil on each side as defined by Justice Story. Now the question is, what is the proper age of having this kind of understanding, which we can say the age of consent. But before discussing it, I would like to discuss one important aspect relating to the age of marriage. Because that child marriage, the concept of that child marriage, and it is a common notion that it has strong roots in the Hindu culture, that child marriage is very prevalent. Yes, it is. But this common view that the child marriage amongst Hindus is prevalent since the ancient period is totally false. And why I'm taking the example of Hindu marriage? For the simple reason that marriage here is not a contract, as we have studied being a law student, meaning thereby where consent and maturity are essential elements, but a religious sacrament and one of the sanskar, that is the rites which is prescribed to every Hindu. Now, if you notice the mantras that were pronounced, that used to pronounce in that marriages, I think most of us or almost everyone has ignored the meaning of that mantras that are usually pronounced or chanted in the marriage. Among these mantras, if you notice the mantras, there is the evidence to show that marriages in the Vedic period were effected when the couple has reached a mature age and were capable of understanding the nature and significance of the marriage ceremony. Because those mantras are from the Rig Vedas. And there is one sanskar ritual that we call as the Pani Grahan Sanskar. there are many rituals during that marriage ceremony. But in the Panigran ritual, which is one of the important rituals during the marriage, there are 7 set of mantras pronounced in that during Panigran ritual. The 6 mantras are the liabilities that has to be created on the bride and groom. And the 7th mantra is actually a place of both bride and groom for each other. They have to take that place for each other. Similarly, in the Saptapadi, that is going 7 times around the sacred fire, which makes the marriage tie irrevocable, at each step, there is a proposal and acceptance relating to the marital life. And the meaning of these mantras furnish strong evidence negating the possibility of mere children being married. It apparently indicates that both bride and groom must be at the age of proper understanding and maturity, which is in fact the age of consent we are discussing about. This practice of child marriage has entered into through that smritis and the later period due to some other reason, various reasons. I am not going to discuss those reasons. But that was not prevalent since the Vedic period. Now, I would also like to cite some interesting thing that we must be aware about a function after the 4th day of marriage. That is called as the Chaturthi Karm somewhere, and somewhere it is called as the Chauthari or like this. This ceremony has much relevance and appears to have been intended for the actual consummation of marriage. The maturity level, generally the bride and groom used to play some tricks in the milk pot or something else. There are many things that are arranged in that ritual. And it reflects to find out that whether both are having mature mind, mature understanding or not. And it is a semblance, as a semblance it follows in some places where the child wife and the boy husband are brought together in a room. Now there is another practice. There was a practice which is not very much prevalent today, under which the girl's residence usually resides with her parents or original guardian till she considered fit to go on the husband's house. It was permissible only after that period. However, a time arrives when a ceremony, which is generally we know him by various names. Somewhere it is called as the Muklava, Gauna, Bolwan, Dwargaman, Anu, Doli, Ruksadi. Now these first 5, that is Muklava, Gauna, Bolavan, Dwargaman, may or may not be proximate to the actual consummation but are related with the attaining maturity of the husband and wife. Nowadays this practice is almost dropped because the girl is married at a later stage, except that child marriage. At the time of Doli or Ruksadi ceremony, the girl generally goes for consummation. If you notice again the rituals which were followed during those Doli and Ruksadi. Hence, all these practices are clear indicators that the age of marriage and sexual relationship must be considered at the age of proper maturity and understanding. Similarly, we will find under Muslim law the principle of option of puberty, under which a girl child may repudiate her marriage on attaining puberty, is also indicative that the maturity of mind is the relevant factor for deciding the concept. Nowadays, there is another debate going on for lowering the age of the criminality in the cases related with the love affairs, which Professor Gupta was also, Professor Verma was also discussing about. The basis of this argument is that the teenagers of the age group 16 to 18 years are matured enough to understand the consequences of their act. True. But in what context they have understood the consequences of such act is a crucial factor. And we are almost not considering this. During my more than 4-year posting as in the Juvenile Justice Secretariat, I had interacted with many such teenagers. And what I find is that their understanding of the consequences of their act or omission is based on the information about the same along with the emotional factors, and are not based on the knowledge about it. Hence, the understanding again, divide of knowledge is immaturity. Being informative and being knowledgeable are entirely different things. We cannot mix it up. The age of consent, therefore, must not be decided using the age bar ratio and biological development of the body. Rather, it has to be decided on the maturity factor, understanding of a person, normal prudence, and as per the knowledge quotient. Even if you go to the scientific studies, the neuroscientific evidence suggests that the adolescent brain undergoes significant changes throughout the teens and beyond. Hence, the age of consent must be decided considering all these aspects and only after subjective satisfaction on each and every trait, and any objective decision must be avoided on this point. I would not take much time. I think I am well within my prescribed time if I'm not wrong. And if I have extended it, I seek my apologies. Thank you very much for allowing me to share my views on this point. Thank you.
No, sir, you are very much within your time, and I'm so glad that you broadened the perspective, bringing a little historical also. So I'm glad that you raise both technical and historical, because as we know, the issue of marriage and age of consent, they are also not devoid or say delinked from the socio-economic, cultural, religious dimensions. So and thank you so much for joining and being part of this event. And we are privileged to have him for two reasons. One, he has been a strong supporter of legislations which protect girl children in the country, and he was also one of the voices in the Law Commission of India, and he was one of the first few who were called for his opinion and his comments and suggestions. So Professor, sir, आपको over to you, sir. Thank you.
Hi. Thank you very much. And though I joined a little late, but when I joined, I think the discourse was only sort of growing from being adolescent to adult. I could not listen to the initial speeches and comments and observations by Honorable Professor D.P. Verma. But I joined when Dr. Rinchen was making his observations, and certainly he raised a variety of issues which he emphasized that are intertwined, like age of puberty, age of marriage, age of consent, and his view was that these are interlinked, cannot be separated, and must be discussed together. True. But at times I often wonder that how the question of age of puberty is brought in this entire discourse. Age of puberty may be as low as 9 or 10 or 11. Age of consent in 1860, if you remember the history of the development of age of consent, and I keep referring to the independent thought judgment in this regard whenever I address my students in the classroom on the question of age of consent, I tell them that even if you are not able to read the entire text of independent thought, on which I always spend more than 1 hour, 1 class hour on one single judgment, I do ask them to read that table where the development of age of consent has been discussed by the Supreme Court. But one thing which even the independent thought judgment doesn't tell is that how Macaulay had prescribed that age of consent. 1860 ka IPC, when brought on a statute book, had the 10 years threshold as age of consent. Macaulay, when he submitted his draft IPC in 1837, he had suggested it to be 9 years. 9 and 10 are not significantly and substantially different ages, of course. But then, certainly 10 was considered to be a reasonable age by the then standards, the standards of maturity and all. And then it was changed in 1891 to 12 years, in 1925 to 14 years, in 1940 to 16 years, and then remained 16 till 2013 amendment. And then it was raised to 18 years. Even before that was done, POCSO was brought in, which prescribed that threshold at 18 years without any exception and all. And as we all know that the independent thought judgment is product of that conflict between POCSO Act and the IPC as amended in 2013, especially exception 2 of section 375 and all. So I often find it a little discomforting when the question of age of puberty is linked to the question of age of consent, because going by the scientific standards and all, the age of puberty hovers around 9 to 11 years. If it is higher, it is 12 years. In few cases, it may be 13 or 14. So are we, in fact, arguing that it should be the same as it is? The age of puberty? Certainly that would be very, very counterproductive. That would be very, very regressive. That would be very, very dangerous. That would be, again, what will take us back to those times, those ages, which we don't want even to remember. Now, if you see this report, number 283 of the Law Commission, report that we are supposed to discuss here, threadbare report, which the learned resource persons have spoken on different aspects of that report, and the report on which I am also supposed to speak on. While Shri Subhash ji was making his presentation, he raised this issue that why the Law Commission of India considered only this age of consent and did not go beyond it. Age of consent to sexual intercourse and not age of consent as far as marriage is concerned. Sir, that was exactly what was asked of the Law Commission of India. In fact, the Law Commission of India, when it had contacted a few persons, and I was also fortunate that I was contacted by the Law Commission of India to participate in their deliberations and discussions and also submit my opinions and all. I was specifically shared with two decisions of Honorable High Courts, one from MP, Madhya Pradesh, and another from Karnataka. And the entire discourse that was organized, the entire discussion and debate that was organized by the Law Commission of India, and what we call reason d'etre for this report is the references, rather twin references that were made by the High Courts in those two decisions, where the High Courts wanted the Law Commission to suggest certain measures, one with the object to decriminalize adolescent love, and second, to confer wider sentencing discretions on the POCSO courts. So as we all know that very extensive, elaborate, detailed, intense discussions and deliberations took place over a period of weeks, days, and months. Probably everyone whom the Law Commission thought that may have an opinion or two on the issue was contacted. Not only oral submissions, but also written submissions were taken up, and this is how we have this 283rd Law Commission report. Now, it's often argued, and I could see in one of the comments as well, that lowering the age of consent would bring down the number of cases where children are. Is that a tenable, feasible argument? Lowering the age of consent is the solution to bring down the number of cases, criminal cases. Is that the object of lowering down the age of consent? And why 18 years is? Why 18 years? (18 years) is because the consensus is that children keep growing and are incapable of taking rational decisions and making rational choices. Now, this is something very, very important. Capacity to take a decision maybe in a child as young as 5 years, taking a decision, or capacity to make a choice, maybe even in a child as young as 4, 5. Children make choices. This can be tested. Now, I'll give you an example. Place a paper currency and coins in front of a child, young child, 4, 5 years, and ask him to choose. The child would be more tempted to choose that coin that glitters, that appears to be more attractive. An adult would be, or more mature person would be choosing the currencies that would have more value in the money terms. Choice has been made by the child. Is that a rational choice? Do they have this capacity to make a rational choice? Rational choice is a choice where you contemplate the long-term consequences of the choice that you make. Now, it's not that disabilities have been placed on children only in the matter of making a choice to choose their sort of sexual partner or a choice to indulge in sex and all. No, it's not. There are many other areas where children are barred from doing things other than indulging into sexual activity purely on the basis of their age. Why are we not concerned about that? I've never heard a debate on lowering the age of majority for a child to be capable of being able to enter into a contract, civil contract. The age of majority is a law of 1875. 1875. Those who are students of law in the audience, they know that how the law of contract doesn't allow a person under the age of 18 years to enter into a lawful contract. But no one cares. Everyone is concerned about children being not allowed to have sex before they turn 18. No one cares that children are not allowed to work in hazardous occupations before they turn 18. There are so many works only children can perform, let me tell you. Only children, tender hands required. Are you going to allow children? Are you going to give agency to those children in every respect? Or you are emphasizing on agency to children only for sex? I don't understand this. I'm sorry, I don't. Especially for girl children. The consequences of early sex for a girl child may be devastating. Devastating. India is certainly not America. India is certainly not a European country. The society is different. Society is different. Values are different. Culture is different. One of the key suggestions, and this very, very important, often we don't find such kind of suggestions. I must commend the Law Commission of India for this very contemporarily relevant and bold suggestion on sex education. Sex education. In a country where even in families that deem and call themselves as advanced families, sex is a taboo. It's a subject that makes parents uncomfortable. Uncomfortable. I'm not saying that this is an ideal situation and should remain so. Certainly not. But this has to be accepted as social reality, which needs improvement. And it would come with time only. Only with time. And as I said that for a girl child, sex may have a long-term devastating consequences. Not the same consequences would ensue or follow for the male involved in that act, including the teenage pregnancies, social stigma, shame, loss of schooling, loss of image, loss of prestige, early motherhood, its consequences. So many things. Very little for or none for the boy or the man involved in that, even if that's consensual, tacit, or otherwise, whatever consent is there. So when the Law Commission suggested that age of consent should be 18, let's discuss that, how this so-called criminalization of adolescent love can be tackled or can be addressed. And if you see the report, you would find that the ultimate suggestion which the Law Commission has given is about minimizing the chances of criminalizing that adolescent love and all. Now, I would request each one of you to read this report. The report is available and can be freely report. I would recommend and suggest that you do read the recommendation part, and also what kind of suggestions have been made by the Law Commission in the POCSO Act, the punishment wala part, and also in the JJ Act of 2015, where Section 18, which talks about different dispositional orders that may be passed by the JJB, it has been suggested that the children's court, even if that adolescent lover is tried as an adult, the children's court has power to choose one of the dispositional orders from Section 18 itself. Another point, and I was glad that Shri Subhash Chandra ji drew our attention to that point, was that you cannot lament the classification of children into in two categories. One where the child would be amenable to the adult criminal justice system for having committed heinous offenses under the JJ Act of 2015, and also argue for lowering the age of consent on the ground that children grow faster, they have more information, they are smarter today, they develop faster. You cannot blow hot and cold in this regard. And this stand I have been taking consistently since 2015, that any argument of yours for lowering the age of consent from 18 to 16 years would weaken the fight to abolish that sub-classification of children envisaged by the JJ Act of 2015, 16 to 18 years, who may be treated as an adult. So that classification is arbitrary. That classification has no intelligible differentia. That classification has no nexus to the object sought to be achieved, and must be discarded. Similarly, any argument for lowering this age of consent would be against the interest of children, and certainly not in the best interest of children. at least in the Indian context, at least in Indian perspective. And I'm very glad that the Law Commission of India in its latest report has made it very clear. I'm also aware, as all of you are, that the government of the day has also on multiple occasions indicated its intentions that they are not contemplating any proposal for lowering the age of consent, and keeping that age of marriage at 18 or 21 as is contemplated, suggested. They cannot exist at the same time. So I know that the other resource persons, participants, guests who are waiting, including my friend who's I think I could see Dr. Vipin Mishra. So I close here, and certainly I would be glad if there are questions directed to me specifically on this issue. I would be glad to answer those questions in the chat box. Thank you very much.
So, thank you so much, Professor Pandey. And there are certain questions, very old questions where, so there are amendments in JJ Act, age 16 and above. How do you see that? So, while I know your standpoint that those are not advisable provisions, but so that I'll read one of the questions that there are negative consequences of adolescent sex, but is criminal sanction the way to stop it? Is it effective in stopping adolescents from engaging in sexual activity? If you can just respond to that, and then we can move to Vipin Mishra ji.
I think it's very is society permitting adolescent sex? Are parents permitting adolescent sex? Aren't we advocating for children of others, for lowering the age of consent, keeping children of our neighbor or children of our friend in mind, and not our own children in mind when we make such kind of arguments? Okay, agree that it may not be effective in stopping adolescents from engaging in sexual activity. I agree. No law can control the biological urges. So should it be unregulated? Because it's biological urge. I'm sorry, I've heard people arguing that age of consent should be linked to age of puberty. I'm sorry. I'm very sorry. Are we talking about a law to be applied to the children of 21st century or something? Society has to teach children that what is safe and what is unsafe sex, and society has to remove that taboo. Once the society develops, once the society accepts sex amongst children, police would not be. Are all cases of sex between children being reported? They're not. They're not. But if they are being reported, who are those who are reporting it? Parents are reporting it. Let the parents not report it. Now you would say that there is provision of mandatory reporting and all. Mandatory reporting provision is not sort of not cast in stone, that can't be sort of changed and all. And dilution has already started, let me tell you. Dilution of mandatory reporting provision is already on its way. Attention may be drawn to the latest judgment of the Supreme Court in X versus Principal Secretary, Health and Family Welfare Department, the state of NCT of Delhi and all, where the Chief Justice who authored the judgment of the court said that how every adolescent girl has a right to safe abortion. It has been specifically mentioned that even adolescent girls have a right to safe abortion. But what does this right to safe abortion mean? The right to safe abortion means that the child has support from the family. That, okay, all right, you had sex with your friend, you got pregnant, now let's go to a clinic where lot of issues are there. Lot of issues involved. The court has said that the medical practitioner is under no obligation under section 19 to report it to the police. Or even if he reports, he need not divulge the name and all. Effectively, that report would not make any impact, make any sense. So obliquely, the Supreme Court is saying parents don't go and don't report. Don't let the criminal law enter your house. Let criminal law be there. Don't let criminal law enter your house. Keep your house in order. As simple as that. So is that question also directed to me, whether there should be any difference in the treatment of children in the light of the new fact and knowledge, including sex?
I think
society has to. Yes, society has to. Society has to. And but let me tell you, and I believe that if you disagree with me, I would appreciate your disagreement and I would be very glad. I know, and this is something I think this should be discussed, debated from subjective point of view as well. Because I believe in that saying that be the change that you want to see in the world. Be the change. So I know that Dr. Vikram, my friend, has a lovely son growing up. My son is now 20. We try to be as open as possible, but still we can't discuss sex with him. We are trying to be better than our parents. We are better than our parents. It would take another probably generation before that openness is there. Treatment is not necessarily by the police, the state. Treatment is primarily by the family itself. How do you treat your child? How many parents would be comfortable in hearing their daughter telling that I slept with my friend last night when I had gone to a friend's party, and mother telling that was it a safe sex or did you take precaution and all? Society has to, of course. Once the society would be more receptive to all these things, probably the law would remain. But the questions that we are discussing, debating, abuse of law, criminalizing, who is criminalizing? Law is only sort of trying to check sexual abuse. And that is what, if you read the object and reasons clause of the POCSO Act of 2012, which is based on a report that shocked each and everyone in 2007. I think every one of you know that Ministry of Women and Child Development had conducted one study, pan-India study, in 2007. The report is available in the public domain, was supported by UNICEF and all, which shocked everyone that every other child in this country faced some or the other form of sexual abuse in this country. It's not about consensual sexual act. Consensual sexual act being criminalized is partly due to the stubborn and very primitive approach of the Indian parents and society towards sex, which they are not ready to change. Thank you very much.
Professor Pandit, thank you so much. Like always, delight to hear you, and also the rebut to a lot of arguments is very important at times, I feel. And the way you put it so strongly, so clearly, putting again the best interest in the center, I think very few speak like that. So thank you so much. And we have Vipin Mishra ji. He's a, as I always say, is more academician than a police personnel. He's a senior IPS officer. He's DIG range Banda at the moment, and he's also one of the, if I can use that word, stalwart on child rights. In his capacity as police personnel, I don't think many people take that vow of protecting children and girl children. So whatever little I know about him, so in his stint at Bahrain, he started linking child marriages with trafficking, and in his tenure, he ensured, at least in that year, that there were almost zero child marriages through his very innovative effort of linking police stations with the panchayats and ensuring by hook or crook that the panchayat heads ensure that there are no child marriages. And since then, whatever I have known about him, he has always taken up things. And as I said, he's an academician, so has done a lot of research on issues. And what Vipinji always leaves us with a question, which I know he will also repeat today, that we must look at what happens to girls who elope in romantic marriages. What actually happens to them? So with these words, Vipinji, the floor is yours, and please share your insights. We are all waiting to hear you.
Thank you, sir. I'm audible.
You are audible, sir. You can start.
ओके, हम शुरू कर सकते हैं. थैंक यू. सबसे पहले तो आज इस इंटरनेशनल डे ऑफ गर्ल चाइल्ड पे जो है डॉक्टर विक्रम श्रीवास्तव जी ने जो ये वर्कशॉप रखी हुई है, मैं उसके लिए उनको धन्यवाद भी देता हूँ और शुभकामनाएं भी देता हूँ, बधाई भी देता हूँ. और एस्टीम्ड स्पीकर्स को भी मैं अपनी ओर से अपना अभिवादन भी भेजता हूँ. डॉक्टर स्तन पांडे सर, जो हम लोगों के काफ़ी समय से, जो करीब 15 सालों से मैं उनसे जुड़ा हुआ हूँ और इस फील्ड में मैं उन्हें अपना मेंटर मानता हूँ. एक अच्छी दिशा उन्होंने दिखाई और क्रिमिनल जस्टिस सिस्टम में एज पुलिस जो इंटरवेंशन होना चाहिए था, उसको उनके मार्गदर्शन में हम लोगों ने काफ़ी हद तक जो है वो किया, कर दिखाया. उसको यूनिसेफ ने भी और यूपी गवर्नमेंट ने भी एक्नॉलेज किया हुआ था. तो वो एक्सपीरियंस भी मैं आपसे शेयर करूंगा और कुछ उसके पहले जो इश्यूज हैं वो भी आपसे शेयर करूंगा. सबसे पहले तो विषय जो है, इसमें क्रिमिनल जस्टिस सिस्टम में काफ़ी मेस है. आपके जे एक्ट से लगायत पोक्सो एक्ट के इंटरप्रिटेशन और उसके एग्जीक्यूशन में जितने भी स्टेक होल्डर्स हैं उनका अपना जो माइंडसेट है वो अलग अलग तरह का है। उसमें जो सिनर्जी है वो आज उस एक्ट के पास होने से लेके आज तक कभी बनती हुई मुझे दिखती नहीं है। जुडिशियल माइंडसेट अलग दिखता है, प्रोसिक्यूशन का माइंडसेट अलग दिखता है, पुलिस का माइंडसेट और रेवेन्यू का माइंडसेट अलग दिखता है। तो इन सब का कोऑर्डिनेशन लेना और इनको इनकी एक सिनर्जी क्रिएट करना ये अपने आप में एक बहुत बड़ा चैलेंज होता है। जहाँ इन चैलेंजेस को हम लोग जो है वो पिरो पाते हैं एक सूत्र में, वहाँ तो सफलता मिलती है, अदरवाइज फिर ये दिक्कतें आती रहती हैं। चाइल्ड मैरिज का जहाँ तक इशू है या गर्ल्स इन रोमांटिक रिलेशंस का इशू है, गर्ल्स इलोपमेंट का इशू है, तो देखिए इसे एक होलिस्टिक व्यू में हमें देखना है। होलिस्टिक व्यू ये है कि हमें अपने बच्चे को एक एसेट के रूप में देखना है सोसाइटी के लिए या एक लायबिलिटी के रूप में देखना है सोसाइटी के लिए। अभी जो ट्रेंड चल रहा है वह जो मैंने अपने फील्ड के एक्सपीरियंस से जाना, खासकर तौर से जो इलोपमेंट के गर्ल्स इलोपमेंट के केसेस हैं, उन इलोपमेंट के केसेस का जो एंड रिजल्ट है वो बड़ा ट्रैगिक रहता है। और इस पे बार बार मैं फोकस करता हूँ कि जब कभी कोई लड़का किसी लड़की के साथ रोमांटिक रिलेशन में आता है और लड़की उसके प्रभाव में आकर घर छोड़ती है, तो फिजिकल रिलेशन बनने के बाद, वह यूज़ होने के बाद, वह जब उसके अंतर्मन के तार धीरे धीरे टूटना शुरू होते हैं, तो एक्सप्लॉयटेशन का एक केवल और केवल विशेष सर्किल बनता है लड़की के साथ, जिसमें उस लड़की को एनी हाउ बस सरवाइव करना रहता है। क्योंकि जो एक आइसोलेशन कार्डन उस लड़की के खिलाफ बनता है, उसमें उसकी अपनी फैमिली जो है वो छोड़ चुकी रहती है। जिस नई फैमिली के साथ वो जुड़ी है उस फैमिली का सपोर्ट सिस्टम भी कुछ खास नहीं बना रहता है। फिर उसके पास और कोई चारा नहीं रहता है सिवाय एक्सप्लॉइट होते रहने के, या अंततोगत्वा इसका एक कोई ट्रैगिक एंड लाने के लिए। इवन ऐसी शादियों के बाद से भी मैं आपको बताऊं, वो शादियां 4 साल 5 साल 6 साल बीतने के बाद वो पेयर्स आते हुए मैंने देखे, और उन पेयर्स ने न केवल आपस में तलाक लिया बल्कि एक दूसरे के खिलाफ मुकदमा लिखवाया और सारे लिटिगेशन हुए जो है। 363 और 366 में जब हम लोग फील्ड में काम कर रहे थे, तो मैं बहराइच एक्सपीरियंस पर सीधे आता हूँ। बहराइच का जो इशू था वहाँ चाइल्ड मैरिज सबसे ज़्यादा था। अक्षय तृतीया के अवसर पर चाइल्ड मैरिज का सरमनाइज होना जो है एक आम बात थी, और उसका परसेंटेज काफ़ी था। वो डाटा जो है यूनिसेफ ने मुझे शेयर किया, और यूनिसेफ के जो ऑफिशियल्स थे वो उस समय मुझसे मिले। तो आज से लगभग वो 4-5 साल पहले का प्रैक्टिस था, और उसको हम लोगों ने केवल इतने ही इंश्योर किया कि इस बार चाइल्ड मैरिज कम से कम जनपद बहराइच में नहीं होने देना। और जो मैं आपको क्रिमिनल जस्टिस सिस्टम के सारे स्टेक होल्डर्स की सिनर्जी की बात कर रहा हूँ, वो सिनर्जी जो है हम लोग जोड़ने में कामयाब रहे। सब लोग इक्वल फूटिंग पर थे, और जिसका जितना पार्ट था वह सब लोगों ने इंश्योर किया। और पहली बार वो था जब बहराइच में हम लोगों ने इसमें न केवल चाइल्ड ट्रैफिकिंग के मुकदमे लिखवाए 370 में, बल्कि कोई मैरिज होने ही नहीं थी। जितने भी मामले थे वो सारे के सारे मामले उस साल जो है वो एक भी सरमनाइज नहीं होने पाए, और उसको यूनिसेफ ने एक्नॉलेज किया अपने डाटा से, अपने फील्ड सर्वे से। इसके अलावा उन्होंने मेरी जो एसओपी थी वो गवर्नमेंट को भी रिकमेंड की बाकी ज़िलों में फॉलो करने के लिए। इस दौरान हम लोग मिशन शक्ति से भी जुड़े रहे। मिशन शक्ति जो उत्तर प्रदेश गवर्नमेंट का बहुत अच्छा ड्राइव है, और उसमें स्कूल कवरेज, गाँव का कवरेज और अन्य जगहों का कवरेज भी बहुत ज़्यादा होता है, और आउटरीच पुलिस के माध्यम से, एडमिनिस्ट्रेशन के माध्यम से गाँव में बढ़ाया जाता है, जिसमें चाइल्ड प्रोटेक्शन के लिए, वायलेंस अगेंस्ट वीमेन के लिए हम लोग लोगों को जागरूक करते हैं। साथ ही सेल्फ डिफेंस के भी गुण बताते हैं, और गवर्नमेंट की जितनी डेवलपमेंट की स्कीम्स हैं उनको भी अवेयर करते हैं। तो ये एक होलिस्टिक व्यू साथ में लेकर चलते हैं, जिससे गांव में हमारी जो पहुंच है लोगों के बीच में न केवल बढ़ती है बल्कि इन नियमों के बारे में बहुत सारी जानकारियां भी उनको होती है। इसमें सबसे पहले जो हम लोगों ने ध्यान दिया वो था जो जेजे एक्ट का सेक्शन 94 है, सब क्लास 2, उसका जो पैरा है बर्थ सर्टिफिकेट का। तो बर्थ सर्टिफिकेट में जो एजुकेशन का सर्टिफिकेट है वह या तो कोई एजुकेशनल इंस्टीट्यूशन देगा, एजुकेशनल इंस्टीट्यूशन अगर नहीं दे रहा है तो कोई हॉस्पिटल है, म्युनिसिपल कॉरपोरेशन है, या उसका एक ऑप्शन है पंचायत। इस पंचायत वाले ऑप्शन पर ही हम लोगों ने ज़्यादा फोकस किया, क्योंकि लड़कियों के भगने के समय एक जो सबसे बड़ी बात आती है वो आती है उनके एज डिटर्मिनेशन के बारे में। गांव की लड़की अमूमन तो स्कूल जाती नहीं, अगर स्कूल गई भी है तो उसका बर्थ सर्टिफिकेट वगैरह जो है मिलना, प्रोक्योर करना, उसको न तो याद रहता है और न इसके बारे में कोई डॉक्यूमेंटेशन प्रॉपर है। तो मिशन शक्ति के माध्यम से जब हम लोग आउटरीच बढ़ा रहे थे तो ये गांव में इंश्योर किया गया कि हम कितने अधिक से अधिक बच्चियां जो स्कूल गोइंग नहीं हैं या स्कूल ड्रॉप कर चुकी हैं उनका बर्थ सर्टिफिकेट बनवा लेते हैं। और पंचायत सेक्रेटरी के माध्यम से वो बर्थ सर्टिफिकेट हम लोगों ने, वहाँ के सीडीओ भी उस समय बहुत सक्रिय थी, मैक्सिमम संख्या में हर गांव में आउटरीच करके हम लोगों ने बनवाए थे। तो उससे हम लोगों ने एक संभावना ये खत्म कर दी थी कि बच्ची हमारी बालिग नहीं है, ये सिद्ध करने में हमें आगे चलकर सहायता होगी। बच्ची अगर नाबालिग है तो हम पोक्सो और जो जेजे एक्ट के जो प्रावधान हैं उनको इन ट्रू स्पिरिट अट्रैक्ट करा पाएंगे। एक तो इससे काफ़ी मदद मिलती है। दूसरी बात यह है कि जब हम जेजे बोर्ड के सामने जाते हैं तो मजिस्ट्रेट के पास भी ये ऑप्शन नहीं रहता है, अगर हम बर्थ सर्टिफिकेट अपनी रखते हैं, कि वह उसके बाद ऑथेंटिकेशन टेस्ट या बाकी चीज़ों के लिए ऑर्डर करें। जब हमारे पास एक हुआ है और इसको मैंने इंश्योर भी कराया वहाँ की जुडिशरी में इस बात को आगे बढ़ाकर। इस एक्सपीरियंस से हमें फ़ायदा ये मिला कि बच्चियों के मैक्सिमम बर्थ सर्टिफिकेट बनाने के बारे में लोगों के बीच में जागरूकता फैली, एक तो पूरे बहराइच में, और हम लोग काफ़ी हद तक उसका डॉक्यूमेंटेशन भी करा पाए। दूसरी बात, गांव के लेवल पर जो ग्राम प्रधान और चौकीदारों का एएनएम का ग्रुप है, उस ग्रुप को हम लोगों ने इसके साथ जोड़ा। उस ग्रुप को साथ जोड़ने का फ़ायदा ये रहा कि ग्राम प्रधान को ही मैंने रिस्पॉन्सिबल हेड किया कि अगर आपके ग्राम सभा के क्षेत्र में कोई भी चाइल्ड मैरिज होता है, उस चाइल्ड मैरिज को हम लोग जो है जो भी एक्यूज का कॉलम बनेगा उनको तो बनाएंगे ही बनाएंगे, प्रधान जी आपको भी बनाएंगे, और ये इंश्योर करेंगे कि उसमें फिर आपके खिलाफ सख्त से सख्त कार्रवाई हो। ह्यूमन ट्रैफिकिंग की धाराएं, चाइल्ड ट्रैफिकिंग की धाराएं भी अट्रैक्ट की जाएं और उसमें आपकी दुश्वारियां काफ़ी बढ़ेंगी। जो भी ग्राम प्रधानों की मीटिंग थी वो हम लोगों ने पूरे के पूरे पुलिस स्टेशन के माध्यम से कराई। हर पुलिस स्टेशन पर ग्राम प्रधानों को, चौकीदारों को, गांव के और मोजिज लोगों को बुलाकर 10-10, 5-5 के पॉकेट्स में उनको बताया भी, और फिर उन चीज़ों को जाके गांव में फैलाया भी, ग्राम प्रधान के माध्यम से भी, अपने जो पुलिस फोर्स थी उसके माध्यम से, जो रेवेन्यू के अफसर थे उसके माध्यम से। तो ये सारा जो एक कंपोजिट एफर्ट रहा, उस कंपोजिट एफर्ट से हर उस गांव में यह जागरूकता फैली कि भाई जो बच्चा है उसका बाल विवाह हमें नहीं करना, और अगर बाल विवाह होगा तो हमारी पहला दायित्व है वो पुलिस को सूचना देना। तो इस तरह से जहाँ भी हमें सूचना मिली, जो हेल्पलाइन नंबर्स थे वो भी हम लोगों ने काफ़ी फैलाए, तो जहाँ भी सूचनाएं मिली वहाँ हम तुरंत पहुँच सके। बाल विवाह की बात अगर हो भी रही है, शुरुआत भी हुई है, तो उसको हम वहीं स्टॉप कर लेते थे और रुक पाए। तो ग्राउंड लेवल पर ये जो एक्सपीरियंस आया वो यही आया कि ये सारे जो स्टेक होल्डर्स हैं, अगर इनकी सिनर्जी कायदे से हम लोग एक अच्छे लीडरशिप में क्रिएट करा पाए तो ऐसा कुछ नहीं है कि हम चाइल्ड मैरिज को रोक नहीं पाएंगे। दूसरा इसमें मेरा इशू ये रहता है कि 363 और 366 आईपीसी के मुकदमे जब भी लिखे जाएं, हमें ये देखना है कि इसमें जो मेंसरिया था, मेंसरिया क्या था। अगर वो ट्रैफिकिंग से है, ट्रैफिकिंग की परिभाषा में मैरिज करने की बात भी आती है, मैरिज के लिए अगर लड़की को फुसला के ले जा रहे हैं तो हमारी चाइल्ड ट्रैफिकिंग के सारे प्रावधानों को आच्छादित करती है। वो सारी चीज़ें जो है हम लोग अगर 370 की आईपीसी की धारा उसके साथ बढ़ाएंगे तो उसकी ग्रेविटी बढ़ जाती है। और जब भी लड़का लड़की को हम रिकवर करेंगे, लड़की अगर हमारी नाबालिग निकली, तो बाकी जो धाराएं हैं उसमें उनको रिलीफ पाने का, जो कल्प्रिट्स हैं उनको कोई मौका नहीं मिलता। फिर उनको सजा होनी है, उनके बेल में दिक्कतें आनी हैं, और भी बहुत सारी जो दुश्वारियां हैं वो उनको झेलनी पड़ती हैं। इसको हम लोगों ने ये भी इंश्योर करा है कि मैक्सिमम संख्या में हम लोग जो भी ऐसे मामले आए उसमें ठीक से प्रॉपर रजिस्ट्रेशन करा सकें। और बहराइच ऐसा पहला डिस्ट्रिक्ट था जहाँ न केवल चाइल्ड मैरिज में बल्कि चाइल्ड लेबर में भी मैंने 370 आईपीसी की धाराएं जो है वो लगवाई, और लोगों को हाई कोर्ट से आगे मतलब हाई कोर्ट से नीचे बेल नहीं मिली, और बाकी केवल वो सारे मुकदमों में चार्जशीट लगी, वो अभी भी अंडर ट्रायल चल रहे हैं। जो है लड़कियों की जो बात आती हैं, तो मेरा बस इतना ही इसमें और ऐड ऑन करना रहता है कि 363 हो, 366 हो, चाइल्ड मैरिज के लिए अगर किया जा रहा है या किसी भी पर्पज़ के लिए किया जा रहा है, तो देखिए हमें बच्ची तो उस परिवार की है, हमें उस बच्ची को लायबिलिटी के रूप में इस समाज में नहीं वो करना है, थ्रो करना है, बल्कि एक एसेट के रूप में करना है। रोमांटिक रिलेशन होना अच्छी बात है, फिजिकल रिलेशन होना भी, अगर वो बायोलॉजिकल नीड है तो उसको एक हद तक लॉ से हम बिल्कुल नहीं रोक सकते, लेकिन शादी हो जाने के बाद की जो फॉर्मेलिटीज़ और लायबिलिटीज़ हैं उसको मीट आउट करने के लिए जो मेरा कपल है वह सक्षम है कि नहीं, उसका एजुकेशन, उसका स्किल डेवलपमेंट, उसका इकोनॉमिक एम्पावरमेंट, ये सब जो ज़रूरी पहलू हैं इन पर ध्यान दिए जाने की ज़रूरत है। और मैं तो ये मानता हूँ कि जो हमारे सस्टेनेबल डेवलपमेंट गोल्स हैं उसमें जो गोल नंबर 3 है गुड हेल्थ वेलबीइंग का, गोल नंबर 3 है क्वालिटी एजुकेशन का, गोल नंबर 5 है जेंडर इक्वलिटी का, और गोल नंबर 10 है इनइक्वलिटीज़ रिड्यूस करने का। इन सारे मुद्दों को एक होलिस्टिक वे में हम तभी पा सकते हैं जब हम किसी भी बच्चे का, किसी भी बच्ची का प्रॉपर एजुकेशन और स्किल डेवलपमेंट करें। बच्ची का अगर स्किल डेवलपमेंट नहीं किया, उसका इकोनॉमिक एम्पावरमेंट अगर हम नहीं कर पाए, तो केवल मैरिज करके बच्ची को एक परिवार से दूसरे परिवार में अगर हम भेजेंगे तो वहाँ केवल और केवल लायबिलिटी होगी। और उसको जो फील्ड के एक्सपीरियंसेस मेरे हैं उससे देखने के बाद से यही लगता है कि ये बात बिल्कुल मौजूद सही होती है। लड़का लड़की भाग तो जाते हैं, भागने के बाद से अगर लड़की के घर वालों ने उनको डिसोन कर दिया तो लड़की बिल्कुल पूरी तरह से लड़के के भरोसे रही। लड़का भी उसी एज ग्रुप का है, पढ़ाई लिखाई से उसका कोई मतलब नहीं। फिर वो मालूम ये हुआ कि लेबर एक्सप्लॉयटेशन के एक विशियस सर्किल में वो पूरा कपल फंसता है, और थोड़े दिनों में जो रोमांस का क्लाइमेक्स है वो जब खत्म हो लेता है तो दोनों एक दूसरे के लिए ही लायबिलिटी महसूस करते हैं। इस बात पे भी काफ़ी शोध होने की ज़रूरत है, और इस पर मैं काम भी अभी कर रहा हूँ, लेकिन मैं इस मंच के माध्यम से इस पर हाईलाइट करना चाहूँगा कि गर्ल्स इन रोमांटिक रिलेशंस पर अभी भी बहुत सारी जो कपल्स की लाइफ स्टाइल है, बहुत सारे कपल की हैपनिंग्स हैं, उनके सारोज और सफरिंग्स हैं, उनको जानने का तो हमें अभी अवसर ही नहीं मिला। हम तो केवल इस बात में अभी अड़े हुए हैं कि साहब नहीं, रोमांटिक रिलेशन को चलना चाहिए या नहीं चलना चाहिए। उनके साथ हुआ क्या, वह सोसाइटी में अपना एक सम्मानजनक जो कंट्रीब्यूशन था वो करते हुए सरवाइव कर पाए या नहीं कर पाए। अगर इन बातों का अध्ययन करने के बाद से अगर हम असेसमेंट करेंगे तो शायद इस मुद्दे को ज़्यादा मतलब ज़्यादा जो है वो अच्छी तरीके से हम सामने रख पाएंगे। वो चीज़ तो हम अभी कर ही नहीं रहे हैं। हम अपने अपने तर्कों के माध्यम से इसको सही और गलत साबित करने में लगे हुए हैं, लेकिन जब रियल पिक्चर आप अगर समाज के सामने रखी जाएगी या बाकी गर्ल चाइल्ड के सामने रखी जाएगी तो शायद स्थिति और स्पष्ट हो सकेगी कि हम जो ये कदम उठा रहे हैं वो वास्तव में हमारे हित में है या नहीं। और मैं समझता हूँ कि अगर इसका अधिक से अधिक एक रिसर्च ओरिएंटेशन बना के और उसकी फिल्में समाज के सामने रखी जाएं, परिवारों के सामने रखी जाएं, तो उसका एंड रिजल्ट काफ़ी अच्छा आना है। ये जो मंच है इसके माध्यम से भी इस बात को कर सकते हैं, और साथ ही इंडिविजुअल लेवल पर ही अगर एक दो केस स्टडीज़ हमने इस तरह की कर रखी हैं और उसके रिजल्ट को जान रखा है तो उसको हम हर जगह कोट करके बता सकते हैं। ये बच्चों की काउंसलिंग में वो जो कपल रेस्क्यू करके रिकवर किया जाता है उनकी काउंसलिंग में इस तरह की बातें जो है बहुत अधिक मायने रखती हैं। और जब उनकी हम काउंसलिंग करते हैं तो उनका दिमाग भी खुलता है कि भाई हमने जो किया है, फिलहाल उसकी ये उम्र नहीं, हमारी उम्र वाकई अभी अपने इकोनॉमिक एम्पावरमेंट की है, स्किल डेवलपमेंट की। तो अगर इस दिशा में काम होगा तो निश्चित रूप से जो गर्ल चाइल्ड है वो न केवल स्ट्रेंथन होगी, एम्पावर होगी, बल्कि हम लोग और एक अच्छी सोसाइटी और जीडीपी में कंट्रीब्यूटिंग कपल का निर्माण कर पाएंगे। मैं इस मंच के माध्यम से इतनी बात करना चाह रहा था। थैंक यू।
थैंक यू विपिन जी। एंड बहुत ही आपका अनुभव जो ग्राउंड का है, उससे जो आप बोलते हैं उसमें कहीं डिस्कशन का स्कोप नहीं रहता ज़्यादा, क्योंकि आप लाइव चीज़ों को देख रहे हैं जो आपके सामने घट रहा है। मैं आगे बढ़ाते हुए एक क्वेश्चन है जो मैं अस्कन जी से, मतलब पार्टिसिपेंट का क्वेश्चन है जो मैं चाहूँगा अस्कन जी उसको रिप्लाई करें। बट बिफोर अस्कन जी कम, मैं हमारे साथ रफीकुल जुड़े हैं, और रफीकुल को मैंने स्पेशली रिक्वेस्ट किया था जुड़ने के लिए। एंड मुझे लगा कि फिर मुझे इससे अच्छा मौका नहीं मिलेगा रफीकुल को एक्नॉलेज करने का और उनको थैंक्स करने का। तो रफीकुल कैंपेन अगेंस्ट चाइल्ड मैरिज के साथ बहुत पुराने से जुड़े हुए हैं, बहुत ही जुझारू व्यक्ति हैं। असम में मुझे लगता है अगर मैं सैकड़ों बोलूँ तो कम होगा कि सैकड़ों चाइल्ड मैरिजेस के कंप्लेन ये हो। और ये लॉ कमीशन रिपोर्ट में पेज नंबर 103 पे फॉर्मली, क्योंकि ये सारी जानकारी समझ जो मेरी बनी थी इस मुद्दे को लेके असम के कॉन्टेक्स्ट में, दिस वाज प्योरली रफीकुल। सो ऑल क्रेडिट टू रफीकुल। एंड आई थिंक रफीकुल आपके कारण एक बहुत एक स्ट्रॉन्ग पोजीशन ले पाया है लॉ कमीशन। एंड आई रीड व्हाट द इशू वाज कि इन असम सम पेरेंट्स अरेंज मैरिजेस बिटवीन माइनर्स or a minor and an adult by signing notarized agreements stating that the minors or the minor and the adult have fallen in love. Now, अगर आप हमारे इसी चैनल के एक पुराने वेबिनार में जाएंगे रोमांटिसाइजिंग रोमांटिक चाइल्ड मैरिज करके, तो आप वहां देखेंगे कि रफीकुल ने ये प्रेजेंटेशन उनके प्रेजेंटेशन में ही दिखा था कि ये नोटराइज्ड एफिडेविट्स असम में बन रहे हैं और कैसे माइनर्स के पेरेंट्स रोमियो जूलियट खुद ही तय कर ले रहे हैं कि ये रोमियो है, ये जूलियट है, 13 साल 14 साल के बच्चों का। और एफिडेविट में लैंग्वेज इज डीप लव और उस तरह के लव यूज कर रहे हैं लैंग्वेजेस इन द एफिडेविट। सो आई कन्वे एक्सट्रीम ग्रेटिट्यूड एंड थैंक्स टू रफीकुल। एंड रफीकुल, आपका जो एफर्ट रहा है, आई थिंक इट हैज somewhere help the Law Commission of India to build an understanding and take a position. So रफीकुल, मैं चाहूँगा एकदम संक्षिप्त में अगर 5-10 मिनट के लिए if you can share about that notarized wala thing specifically and few other things. So I think you have 10 minutes to share, Rafeekul.
Thank you, sir. Bikram, if I am audible, I should say that I cannot cover this 10 minutes. I don't have the depth to speak about this. Anyway, thank you for giving me the opportunity and recognizing my efforts that I have been through these past few years. So I'm actually proud of being called here in this webinar, esteemed webinar, where the Law Commissioner's report has been discussed. Anyway, we could see that we are working or fighting against child marriage. But what moved us most that the legal practitioners who should be the keepers of law and protecting people, including children, they are special. They have special privilege to be protected it was found that those learned people, some of the learned people were misusing the legal provisions, and actually it was not there in any legal provisions, but they twisted the law and misguided the common people and mostly the illiterate section. We have this issue of child marriage in these marginal communities, and particularly who are from a very economically backward background. So those people usually little learn. So when they come across their adolescent daughters, they have to find out some way, because we have already created the awareness that 18 years is the minimum age defined by law or PCMA, so you cannot marry them. So before that, marriages were without any hindrances. So children were married without any opposition from any side. So when we created this awareness, those people went to the legal practitioners and tried to talk to them. Legal practitioners coerced the things, and they have found some way. They said that they have certain ways that none of the parties will be legally liable for doing these things. So when we came across lots of such paper intervening individual child marriages, I had a talk with Sir Bikram, this independent thought founder, and I also talked to some former NACG like Dr. Chiranjeev Kakoti. So it was actually their credit that they advised me the ways to work on. We found that the legal practitioners identified the families of the child and stated that there are certain things which could not be prevented, like the child, a 14-year, 15-year. We have come across 13-year-old child also, that she is in love with someone, and who maybe mostly aged adults, and that if any hindrance is there, if we try to disconnect this love affair, then the child might commit suicide. So that's how they are bound to conduct marriages, and that they will be living in the parents respect houses of respective parents. And there were certain provisions, like if the thing when the child comes of age, the marriage will be solemnized. And then there were other provisions that if any of the parties breaches this contract, then they may be liable to fine, which might vary from 1 lakh to 10 lakhs. And some legal practitioners demanded as per their wish, and looking at the situation, we have instances of some practitioner demanding 25,000 rupees for an agreement. That was really appalling. We even talked to the family, that but the family was afraid of the practitioner and said that we cannot go against him. Then that's how these things keep kept escaping. So Mr. Bikram Srivastav, the founder of Independent Thought, advised me and asked me to compile the things and sit in a consultation. The things came out, and uh, these things were subsequently forwarded. Sorry, these things were subsequently forwarded to NCPCR, and finally, it was really gratifying that these things found its way into the Law Commission's report regarding uh, age of consent of child. So we are extremely very happy with the Law Commission's report, which has stated that it is a disturbing development. Those words are really somewhat messy words. That this development is termed as disturbing development, and there is another instance of words massive words used like deeply concerning. So when these marriages were not actually with the consent of children, if we see the background of the child, and we'll find that actually they were forced. The children were forced to marry the person that the parents chose, but they took resort to the thing that they were in a romantic relationship. Most of the cases were that the parents were forcing the children marry in the shadow of this romantic relationship. Anyway, these are actually after this reporting it to the NCPCR, we found that, and there were many media reports also regarding these things. Media friends should be thanked for that. And subsequently, we found that these things, particularly practiced in the lower part of the Assam, came to a reduction. So even after that, there would be a few
So
such
thank you,
things that we
Rafiqul.
came across, but the parties were not willing to surrender those copies to us. Anyway, we had a reduction in that, and I am really grateful to the Law Commission and this program,
Thank you,
and
Rafiqul.
I am actually very happy being invited. And I have to say that I am not in a very good position in relation to the site and network. I am actually out and standing in a sea beach. Noises may be coming from around. I again express my gratitude to
No
giving me
issue,
this
Rafiqul.
chance and recognizing.
Yeah. Thank you.
I should express my gratitude deeply. Thank you so much, Sir Vikram.
Thank you, Rafiqul. Thank you for the sharing. And uh, I'll request Professor Pandey to take up one question. So the question says that it's basically for all panelists. Because age of consent is a criminal law, is there any evidence to show that criminal law has helped reduce child marriage or improve health outcomes? So if you can, sir, quickly deal with it, and then I'll hand over to Sanjay ji for
Very
final words.
interesting. In fact, very interesting question, and very relevant, very pertinent as well. That brings into focus the role of law in bringing about social transformation. Age of consent is part of criminal law. There's no doubt about it, because age of consent is decided by criminal law. But then age of consent is also part of civil law. In fact, in my discussion, I had mentioned this, that I can't enter into a contract unless and until I am 18 years of age. This is Indian law of contract since 1872, based on the Indian Majority Act of 1875, meaning thereby not based on Indian Majority Act of 1875 didn't change that. And there have been n number of judicial decisions of the Supreme Court where they said that 18 years is the age under which you won't be able to enter into a contract. There also you have to signify consent, which you are not capable of. तो ये कहना कि age of consent is criminal law is correct, but age of consent is also civil law. Anyway, is there any evidence to show that criminal law has helped reduce child marriage or improve health outcomes? Criminal law may not, as far as child marriages are concerned, because child marriages are being performed even in the name of culture, even in the name of tradition, even in the name of religion. Unfortunately, there have been inconsistent decisions of a certain high court, where the high court condoned child marriage on the ground of religious practice. religious practice. Religion allows marriage if the girl attains puberty. Don't you think that such attitudes, such opinions would dilute or weaken the fight against child marriage? The second is that why parents deem marriage as the ultimate salvation for their girls. मुक्ति उनकी भी तभी है और बच्ची की भी तभी है जब शादी हो जाए, उसकी शादी हो जाए. Now this attitude would again weaken this fight against child marriage. The societal attitude where the society believes that the father should be helped in every respect, every aspect in getting his female child married and all. तो मुझे लगता है कि सब कुछ क्रिमिनल लॉ पे ही डाल देना जो है वो ठीक नहीं है. That because child marriage is still an issue. Criminal law has not helped reduce child marriages the way it should have. But have we tested criminal law in every case of child marriage? आज भी एनसीआरबी का डेटा उठा के देखिए, चाइल्ड मैरिजेस का जो आंकड़ा है सरकारी गैर सरकारी, वो चाइल्ड मैरिजेस को लगभग 27% अब बताता है कि 27% हो रहा है. 50% था 7-8-10 साल पहले. 27% हो रही है चाइल्ड मैरिजेस. 50% से 27% पे आए ना. लेकिन एफआईआर कितने चाइल्ड मैरिजेस में हो रही हैं आप आंकड़ा उठा के देखिए ना. एनसीआरबी के 500 से 700, 500 से 700. तो क्रिमिनल लॉ खुद तो अप्लाई नहीं हो जाता, उसको अप्लाई करने के लिए सोसाइटी को एफर्ट्स करने पड़ते हैं. तो जितने केसेस जो हैं वो पॉक्सो में चले जा रहे हैं, उतने केसेस अगर चाइल्ड मैरिज के चले जाते पुलिस के पास और पुलिस उतनी ही प्रॉम्प्टली उन केसेस को इन्वेस्टिगेट और करती, तो शायद चाइल्ड मैरिज का जो नंबर है, जो आंकड़ा है, वो निश्चित तौर पर और भी उत्साहवर्धक होता, which is not the case. That is highly disappointing, and that is how I would answer this question. Thank you.
Thank you so much. And in fact, it triggers me to maybe organize another webinar. And in one of the discussions before the Parliamentary Standing Committee, where they were looking at the Niti Aayog report for the increasing the age of marriage from 18 to 21, and that whole report of the task force is purely on this health indicators. How early marriage leads to more IMR, CMR, MMR, and all those stuff.
Documented evidence.
Documented evidence. So if I reverse the question,
evidence, medical opinions, and medical opinions of not only the gynecologists in India but the world over. World over.
Correct. So if I reverse the question, it becomes more complicated and interesting. So thank you so much from my side, and I'll hand over to Sanjay ji for a formal vote of thanks and then closure. Thank you everyone. Yeah.
बहुत धन्यवाद. और बहुत सारी बातें जो लास्ट के पैनल में श्री विपिन जी से और एक पांडे साहब से सुनी.
Sanjay ji, your voice is cracking.
Voice is cracking. अभी आवाज आ रही है आपको?
हाँ, better, much better sir, much better. So I think Sanjay ji lost the network. On behalf of, say, Campaign Against Child Marriage, which is part of the larger structure of SAIEVAC, which is a regional South Asian regional body to end violence against children. So
आपका आवाज आ रही है? Hello?
sir, jaldi.
Vikram ji, आप conclude कर दीजिए please.
Yeah, I was only doing that. So on behalf of Campaign Against Child Marriage, NACG, EVAC India, and SAIEVAC, as I was sharing, it's a regional South Asian regional body which works on ending violence against children. So thank you so much. Thanks to everyone individually. So let me start with people who are there at the moment. So Vipinji, thank you so much. As always, you always take out time for such issues of children. Professor Pandey, as always, I don't want to thank you because you are such a part of the team and family for such causes. And then, if I can start, special thanks to Professor D.P. Verma ji, who is member Law Commission of India, and has very strongly placed this position, and what led to Law Commission of India coming with such a strong and such unambiguous report. And then Dr. Inchin Chopel, who was there to share his blessings and support as part of the SAIEVAC movement. And then Shri Subhash Chandra Sharma ji, who is part of the Patna High Court JJ committee. And thanks for his in-depth sharing, both legally, and he also went to the historical background and all. And the special invitee, if I can say, Rafiqul Islam, who is the person on the ground, and such people make sure and ensure that girls remain safe, and we can work together and for their betterment. So thank you again. Thanks for all the people who joined us live, and also people who actively participated and shared their comments and questions. So thank you so much. सभी को नमस्कार.
नमस्कार. Thank you very much. नमस्कार विपिन जी. नमस्कार.
लोगों ने चेक किया, एक बहुत अच्छा